Okay, we're back on the record for open meeting, and this is, again, for the board members to discuss matters that are identified here as we've indicated in prior hearings. We can't discuss things outside of open meeting. So if there are materials that have been filed or part of the record that we want to talk about as board members, we have to do it at an open meeting. So that's what we're doing. So who would like to start?
I'll start. You started this discussion with the exchange that you had with Ms. Noonan about the backup contingent water supply plan. And there was actually just recently discussion of the letter from then Chief Sachem Thomas. I find it nearly impossible, and I want to be careful because some of this information is confidential or redacted, so I'll keep it very general. But when we have a contract between CREC and Chief Sachem, and then a declaration that Charlestown is the source of water for that contract, and then we have a letter from the same party who signed the contract stating fairly unequivocally that Crandall Farm in Westerly would be a great place for that water infrastructure. I feel very confused about how we assess whether there's an adequate source of water, or even the ESS study that was shared with council for the town in regard to the impacts on a portion of the aquifer. It's a situation, it's an untenable situation for me as a board member to try to determine what the source and impact of that water supply would be, because it seems so unclear as to where it's really from. So I guess that's unsettling, to say the least.
I just want to mention again, so right now we are talking about backup to backup water supply. The main issue is that we do not have a detailed map that basically talks about, we were given a map. I don't want to use the word which everyone was using at the public hearing, a dot on the map. But yes, that map was, the details were not there. So if we have that information with us, that basically says from where the water is coming from, that talks about the environmental issues, that can talk about the transportation issues, the road network and everything, that will go a long way in helping us to know, and not only us, I do not think, again, the location of well could be or should be classified information. It's the location of the well, right? So if we know from where, if we know, or if the community knows from where the water is coming from, they will be more informed, the communities will be more informed, and it will help us to review the application, and it will go a long way.
I don't know that we've seen, that our rules require that you have to, the applicant needs to say what permits they need, what federal permits, what state permits. I don't know that we've seen that in regard to this contingent backup water supply, but certainly you could not apply for a permit for a source water without having the location. So for me, it is that basic question of where is the location of this proposed source of water, and who gets to determine that, and I think this board needs to.
So just want to make sure whether, when you say location, you mean location means which town it's coming from, or you want to know where, again?
Well, the town at the broadest level,
yes.
But no, where is it coming from? You can't look at its impact on a sub-watershed or an aquifer without knowing where the well will be.
Yeah.
Determine whether or not the water is of sufficient quality to provide what the plant would need.
And again, the letter that was signed by the chief, he's the same chief who basically signed the agreement with Energy for the water supply, right?
Right.
Okay.
And there were additional questions raised at the prior hearing regarding the governance concerns within the tribe. While two members of the tribe are parties to the contingent water supply agreement, we did have information, at least from another faction of the tribe, that they're not authorized to enter into that. And it's unclear whether anyone's going forward with that matter internally, since we wanted to make sure that we were not getting embroiled in the internal governance problems that the tribe has.
Yes, I think we had to walk a line there. There's a lot, and what we received from both parties in regard to that proposed intervention motion made clear that there is a long-standing dispute about governance issues, and the state of Rhode Island seeks to allow the tribe to determine its own governance structure, but clearly that's a disputed issue. One we didn't want to wade into. You said at that hearing, I believe, that's not really in the jurisdiction of the Energy Facility Siting Board, but what is, I think, is knowing where the source of water would come from for any water supply. That was part of a contract between Invenergy and another party.
I agree, like again, we don't want to get too much involved into the internal matters of the tribe, but don't you think we should know the person who is signing the agreement, whether he or she is authorized to sign the agreement or not, or whether that agreement is valid or not? Again, we received an agreement between the Invenergy and the Narragansett Indian Tribe, and we are going with that agreement. But since the question has been raised that the persons who are signing this agreement are not authorized to sign it, don't you think we should have some sort of a review that basically says that yes, those folks are authorized to sign? No, maybe not.
Well, if you...
I think it might be something that we would want the applicant to establish.
Right, the agreement, which I believe is marked confidential, so I won't get into it unless there's a way to have an executive session or something. I want to really be careful of that. But I think that is one of the internal matters of the tribe, and certainly the applicant has to feel they have a sound contract. But I think this board needs to know where the water's coming from. So, Madam Chair, do you have thoughts on how to handle that?
Well, there's we can have a show cause here. We're going to order a show cause hearing to establish that. But I think we would want to discuss the other matter as well. And we have this on the agenda for consideration, having to do with the contents of the December 1st letter.
Before you switch to that, then I'll just simply say that I don't feel like we have a sufficient level of detail and clarity on that backup water supply plan to have a meaningful reaction to it. And now I'm going to switch to the letter dated December 1st from John Island to the board. Filed with the board on December 4th.
that letter addresses the interconnection issues. I think that the first thing we have to note is that there, in addition to this docket, we have another docket that involves New England Power, which does business also as National Grid, and Invenergy have the transmission concern in order to operate the plant has to have electricity. And the idea has always been that it would connect with the transmission line, which is essentially there, very close by. From the December 1st letter, we know that Invenergy has been dealing with New England Power Company or National Grid with ISO regarding the interconnection and the interconnection fee under ISO New England's tariff. So what's referred to as the large generator interconnection agreement. Apparently, there have been difficulties with the negotiations, and Invenergy's taken a position that the current tariff regarding the interconnection particular costs that are issued have been the responsibility of the interconnecting generating facility. And Invenergy was taking the position that the generator should not have to be responsible for those costs, that the costs should be socialized. And in this case, I believe that means it would be socialized throughout the area that ISO New England controls. ISO New England, the independent system operator for the New England grid. Those negotiations apparently, as we know from the letter, unsuccessful, and Invenergy has essentially sued ISO New England and National Grid before FERC, Federal Energy Regulatory Commission, regarding those costs, whether or not they should be socialized or that Invenergy should be responsible for them as the connecting generation facility. That the obvious result, if Invenergy were to prevail, of course, is that this proposed merchant generation plant cannot claim that it wouldn't place any costs on ratepayers, because that would mean that ratepayers in New England would be responsible for those aspects of the transmission costs. That's essentially the issue here. Without knowing the result of that action at first, we don't know. We can't evaluate the cost of the facility because that's a cost that has heretofore not been contemplated as involved with the facility. So that makes a change that I think we need to consider.
I agree. In preparing for this, I was looking at some of the pre-filed testimony, and I think we all remember that. And I don't know how much we want to get into it now, because I think we should have a show cause hearing. So I don't know how much you want to do, but it's been stated over and over by Mr. Nyland and the attorneys representing Invenergy that this is, I'm reading from his pre-filed testimony, this is a privately financed project without seeking any ratepayer funding. So I would observe that there's several venues where things are happening. We have a separate docket, but as has been stated many times, we build a power plant without a transmission line. So they're related. There was a but-for term used in some of the FERC filings. So I think it is a change, which there was a letter from the town and CLF which talked about the PUC advisory opinion, because one of the critical elements in Section 11 of our Act is obviously the cost and the need. And I think some of the things that we've been presented with at times, I think quite a bit after maybe they've been in the works, would raise new questions about cost and whether it's entirely privately financed and about need. So I'm concerned about that in regard to some of these key findings that we need to make. So I think we need more, I think we need to consider whether those, like the FERC decision, which I believe it was stated would be within 60 days, or perhaps that was wishful thinking, but I know that was in one of the filings, whether we should suspend these hearings to find out the answer to that, because as you stated, that raises it really speaks to a fundamental part of the application.
I just want to say that it is very important that all the issues should be resolved before we start the final hearings. So the issue of the ratepayers cost, the issue of the water supply plan should all be resolved, and it should be very transparent before we start the final hearing. So having the show cause hearing will be a way to go.
All right, then I would move to conduct a show cause hearing to determine first whether the contingent water supply plan with the Narragansett Indian Tribe as submitted contains sufficient detail for the board to fully evaluate, and or whether the contingent water supply plan with the Narragansett Indian Tribe should be dismissed from the pending application, and two, whether the application as submitted under Energy Facility Siting Board Rule 1.5 and 1.6 would be sufficiently changed as to the impact on ratepayers so as to require suspension if Invenergy's complaint of pending before the Federal Energy Regulatory Commission is successful.
Second.
All in favor?
Aye.
Aye.
And I believe we could schedule we have a hearing date presently scheduled, although nothing to do. But perhaps this, on the 18th of December.
You're just looking at our rules, which is 1.15 of our rules. A show cause hearing shall be scheduled not later than 10 days and not sooner than 48 hours after the issuance of a show cause order. So we're having that discussion now. A lot hangs on when we issue the order, which generally we try to turn around quickly. But we have that date of the 18th, which is less than a week from today, which would be, work for us for certain. But would we need witnesses, or I guess I'd observe to the party that some of that in regard to the water supply plan and some of the sensitivity, I'm not quite sure how we'll handle answering the questions unless the application is going to have more disclosed on the record. But I think it may be necessary to have witnesses to get at some of these questions, and I'm certainly aware that it may be hard for people to travel within a week. So I think the timing is a bit tricky with the holidays. I'd certainly be prepared to do it on Monday the 18th if the parties and any witnesses they need could make that happen.
Under the coordinator or council, do we need to set the date for it?
We do have to say.
And is the 18th an appropriate date for it, or is it not within the allowable time frame?
Do you think we should speak with the applicants also, whether they have enough time to prepare for this request?
The 18th would be a day if the parties want it. If the applicant needed additional time, they would certainly ask for additional time. And in the matter can be scheduled, however, if they don't, then the board has to. Microphone, please.
Yes, and in terms of the other questions that you raised, I think all of those should be addressed by the parties. So,
Wait, Madam Chair, I'm not sure I understood that. Are you saying when you say they should be addressed by the party, was I suggesting something different? What did you mean by that?
no. Deciding whether or not it's necessary to require testimony, whether or not the applicant has sufficient time to prepare it, by that can be addressed in responding to the motion that we just passed, and that we are.
So I would suggest that since we have the 18th, that we get an order out within 24 hours, and then the 18th is more than 2 days and less than 10 days from the time of our order. If we find there's compelling reasons that we can't do that, we could cancel that date and reschedule it.
The applicants can file a motion for extension of time if they need extension of time. Microphone, please.
Okay, very good.
Can't hear.
That was just that if any of the parties require additional time, that is, that they don't think that they can be prepared to go forward on the 18th of this month, that they can file motions for an extension of time.
And we presumably would hear those motions on the 18th, or would you as the chair, since they'd be procedural motions, be able to rule on those and let them know? I'm just trying to play out how, if they need more time, how we would consider it.
Yes, I could rule on that as a procedural matter, and that we'll know after we issue an order. Anything further?
Just looking at the agenda, was that it?
Unless there's anything else you wanted to discuss.
I think I'd make a motion to adjourn. I move to adjourn.
All in favor? Aye. Thank you.